federal judge in California blocked the Trump administration on Friday from making indiscriminate immigration arrests in the Los Angeles area and from denying detainees the right to consult with a lawyer. The 2 temporary restraining orders issued by the judge represented a sharp rebuke of tactics that federal agents have employed in and around Los Angeles during waves of immigration raids that began last month. In the orders, the judge, Maame Frimpong of the U.S. District Court for the Central District of California, directed agents to stop racial profiling in the course of seeking out immigrants and mandated that the federal government, which has deployed hundreds of agents from Immigration and Customs Enforcement and other agencies in Los Angeles County, ensure detainees have access to legal counsel. What the federal government would have this court believe, in the face of a mountain of evidence presented in this case, is that none of this is actually happening, the judge wrote of the tactics barred in her order. She said that roving patrols without reasonable suspicion violated the Fourth Amendment of the Constitution and that denying access to lawyers violated the Fifth Amendment. The ruling, which remains in place for up to 10 days, came in response to a lawsuit filed last week by immigrant advocacy groups, led by the American Civil Liberties Union of Southern California and the nonprofit Public Counsel. A fuller hearing is expected in the coming weeks, as the groups seek a more durable order, known as a preliminary injunction. Los Angeles, the largest city in the largest blue state, has become the center of President Trump's efforts to ramp up immigrant arrests to achieve his pledge of mass deportations. It is also about 30% Latino and is home to the nation's largest population of undocumented people. During a hearing on Thursday, the judge was skeptical of the government's assertions that it was not violating the constitutional rights of people, and that agents were stopping immigrants based on the totality of circumstances, rather than relying on race. In addition to ICE, which is responsible for detaining and deporting immigrants, the Trump administration has tapped the Border Patrol, the FBI, and the Drug Enforcement Administration to assist with an aggressive enforcement operation in Los Angeles that prompted several days of protests last month. Agents have arrested people in parking lots, in tow yards, and on job sites like restaurants. Some encounters have been captured on bystander video, and in some instances, the arrests have appeared to be roundups of random Hispanic people by armed agents who drive up in unmarked vehicles, in military or plain clothes, wearing masks. Mark Rosenbaum, a lawyer with Public Counsel, said the order reflects there is something very wrong when the federal government goes to war against an American city and ignores the Constitution. He added, hopefully this ends the actions of the government rounding up car wash workers and other hardworking people like they were domestic terrorists. The mayor of Los Angeles, Karen Bass, said the judge's ruling represented American values and decency. During the hearing on Thursday, Sean Skedziewelski, a lawyer for the federal government, defended the tactics that the agents had been using in Los Angeles. He said that when they encountered people whom they weren't initially targeting, agents can't put blinders on. Judge Frimpong described the government arguments as very general, saying that they, quote, did not really engage with the high volume of evidence that the plaintiffs put in the record of the things we have all seen and heard on the news. She also said that the government had failed to explain how agents selected locations for sweeps, such as bus stops, beyond the fact that people congregating there are of a particular race or in a low-income neighborhood. I'm not really satisfied, she said. The lawsuit was filed on July 2nd, accusing the Trump administration of unleashing indiscriminate immigration operations that have swept up day laborers, car wash workers, farm workers, caregivers, and others described as the lifeblood of communities. Individuals with brown skin are approached or pulled aside by unidentified federal agents, suddenly and with a show of force, and made to answer questions about who they are and where they are from, the complaint said. In her 52-page ruling, Judge Frimpong said that the government may not rely solely, alone, or in combination on race or ethnicity, on a person speaking Spanish or English with an accent, or on a person's presence at a particular location, such as a day laborer or agricultural site, or type of work performed to establish reasonable suspicion to stop and detain people. In her ruling, she wrote that during the hearing, Government lawyers had argued that the advocacy groups had not produced evidence that race was a motivating factor for what the groups said were unconstitutional stops and arrests, that any particular agent had engaged in unconstitutional stops and arrests, or that those stops and arrests were not consensual. But the evidence before the court at this time portrays the reality differently, she said. She criticized the government lawyer for pointing to arrests at Car Wash in Whittier, a town outside Los Angeles, as providing agents with reason to return again and again over several days to take more people. In fact, they ended up detaining a U.S. citizen there, she noted. The reasoning is circular at best, and no details were provided to support the idea that the multiple visits were indeed based upon intelligence or investigation, the judge wrote. Mohammed Tajzar, senior staff attorney with the ACLU and counsel in the case, said the ruling confirmed that no matter the color of their skin, what language they speak, or where they work, everyone is guaranteed constitutional rights to protect them from unlawful stops. While it does not take a federal judge to recognize that marauding bands of masked, rifle-toting goons have been violating ordinary people's rights throughout Southern California, he said, we are hopeful that today's ruling will be a step toward accountability for the federal government's flagrant lawlessness that we have all been witnessing. Tricia McLaughlin, a spokeswoman for the Department of Homeland Security, said that a district judge is undermining the will of the American people. The outcome of the case could have implications for how federal agents conduct enforcement operations beyond Los Angeles, according to legal experts. In a court filing in support of the suit, California and 17 other states with Democratic governors said that aggressive enforcement tactics had harmed local economies, prevented people from seeking medical care, and disrupted the daily life of residents. Although defendants claim to be conducting a targeted operation aimed at criminals without legal status, they are instead conducting stops without reasonable suspicion, which in turn has impacted countless Los Angeles residents regardless of immigration status, the state said in the court filing. The federal government said in court filings that agents had followed the law when they stopped people whom they had reasonable grounds to suspect were undocumented. Consistent with the totality of the circumstances approach, agents may consider the location of the encounter, whether it was in a public place or businesses known to employ aliens without documentation, including specific streets, parking lots, and car washes, it said. The lawsuit accused agents of confining people for days in a dungeon-like site in Los Angeles, known as B-18, intended for just hours-long stays, and pressuring people into accepting rapid deportation without allowing them to contact lawyers. In responding to the allegations that some detainees did not have access to lawyers, the government argued that the plaintiffs were basing their claim on, quote, past limitations at a holding facility in Los Angeles. It said that operations there had been normalized on June 24th, and that lawyers had since been able to reach clients. The judge wrote in her ruling that plaintiffs have sufficiently established that their missions of providing legal representation to immigrants, such as those allegedly detained at B-18, have been frustrated by defendants' actions. Moreover, she agreed with their argument that there was sufficient likelihood that they will again be wronged in a similar way in the future. On Monday, heavily armed federal agents and National Guard troops marched through MacArthur Park, at the heart of an immigrant enclave of budding downtown Los Angeles. Thomas D. Homan, appointed border czar by Mr. Trump, had pledged that deportation efforts would target immigrants with criminal records. But initial detention and deportation numbers fell short of the president's goals, which led to a directive from Stephen Miller, a senior White House aide, to drastically increase them. Since then, there has been a notable increase in the detention of immigrants who don't have criminal records.